So why, and then they point to sort of a number of different laws that dealt with restricting firearms,
Yeah.
especially, Bowie knife bans and things of that nature. You've written a lot about this. Why is this logic not correct in your view? Like where are these judges going wrong?
So if you're going for the historical analogies, I've got an article I co-wrote with my friend Joseph Greenlee that will be published in Notre Dame Law School's Journal of Legislation in 2024, but it's available on my website right now in its draft form. Again, davekopel.org. It'll be on the homepage, and soon should be on ssrn.com, which is a great repository for all kinds of scholarship. And so we looked at the history in America from the Jamestown settlement in 1607 up through 1899, which is the point at which Heller said, or Bruin said, the stuff after that is really not very informative about the original meaning of the Second Amendment. And because Bruin's historical point was, yes, some laws can be informative about the meaning of the Second Amendment, especially when they come early. So a minority of states, starting in the 1810s, had concealed carry bans. And from that, Bruin says this shows that the legislature can regulate the mode of carry. You can require open carry or require concealed carry, but you can't ban both. So looking at the history of arms bans up to 1900, the Bowie knife is certainly the thing that gets the most attention. Starting especially in 1836, when in the Arkansas legislature, the Speaker of the House and another legislator start insulting each other, have an argument, and then they both draw Bowie knives and get into a fight, and one kills the other. And that was an atrocious thing. And there was, I think, also a problem of people carrying knives or other weapons, for offensive purposes rather than legitimate defense. But the long story of Bowie knives in America is that sales bans on them were quite rare, as were possession bans. And the mainstream approach of regulation was to say you can't carry it concealed. If you want to sell it to don't sell it to a minor at all, or don't sell it to a minor unless there's parental permission. And if you use it in a crime, you're in extra trouble for using that. And that's the approach that got applied to a lot of other controversial weapons as well.
Right,
and in fact,
clubs and all this other stuff.
Right, and the
pistols sometimes as well, right?
This starts with Georgia in 1836, where they banned the sale of most handguns, other than the horse pistols, which are huge things that you'd wear on saddlebags on a horse, but are pretty big for carrying around when you're not mounted. And Bowie knives and dirks and other. Right. That's another type.
But these weren't. But like you're saying, these weren't sales bans like an assault weapons ban is.
Well, it was certainly a sales ban on those things I just mentioned. Okay. But then the Georgia Supreme Court in 1845 held that all that was unconstitutional because it violated the Second Amendment, and said the only part of this that's constitutional is the concealed carry ban, which is fine, but not the sales ban, not the open carry ban, and not the possession bans. And notably, the U.S. Supreme Court in the Heller decision treats this 1845 Georgia case, Nunn versus State, as perfectly capturing, said the U.S. Supreme Court, the relationship between the first and second clauses of the Second Amendment, and Nunn gets extolled more than any other case precedent by the Heller decision. So it's that's fairly powerful. And then. Well, let me wrap up on the gun bans. The only thing you've got after that as actual bans on types of guns is Tennessee in 1879 and Arkansas in 1881 banned the sale of guns other than the Army and Navy type, banned the sale of handguns other than Army and Navy type revolvers. The Army and Navy type are, as the name indicates, they're big revolvers that officers or artillerymen or cavalrymen would have as a sidearm. They're the most powerful handguns in existence, but because they're big, they're hard to conceal, and those states both ban concealed carry. And the courts there in the Tennessee and Arkansas uphold that and say, yeah, under our state right to arms, you've got a right to militia type arms only. And these are militia type arms, but not a little pocket pistol, like a Derringer you'd carry around in your pocket. And so that's it for handgun bans. One that was unconstitutional under the Second Amendment, and two others that banned small concealable guns while affirming the right to own the largest and most powerful guns. And the gun ban lobbies say, "Oh, so look at Tennessee and Arkansas. Those are our precedents for banning banning most modern centerfire rifles. Supposedly, that's our analogy." And then the one thing you'd add on to that, in 1893, after a series of incidents where black people used repeating rifles to protect themselves against lynch mobs, the Florida legislature enacted a law saying you can only have a repeating rifle on your person if you get a license from the county commissioners, and the license fee is $100, which was a lot of money then. And then in 1901, they added handguns to that. And as the Florida Supreme Court Justice Buford later wrote in a case involving that, he said that it's obviously a violation of the Second Amendment and of the Florida Constitution. And by the way, I was around in the legislature in 1901 when this law was passed, and it was never intended to be applied to the white population. And it was intended to be enforced against rural black people primarily.
Yeah, it's very typical of that era of gun control laws in the South.
Yeah. Yes.
Right. Yeah. That's not unfortunately an uncommon thing. But
right.
But so I
just want to add one thing to that.
Mm-hmm.
The fact that they discriminated against black people doesn't mean that that's the only people the legislature didn't like.
Sure.
For example, in Tennessee and Arkansas, when you say the only handguns you can have are the best and costliest ones, of course you're disarming black people because they're, as former slaves, most of them are pretty poor, but you're also preventing poor white people from buying new handguns. And, the legislatures thought that was swell too. I mean, they were suspicious not only of the black population, but of a lot of the poor white population as well.
Sure, certainly. But so I guess the core argument, though, is essentially that there really aren't good analogies for these types of modern assault weapons bans in the relevant history.
Not for right? Possession, not for sales and possession bans.
Okay.
To say limitations on carry, limitations on sales to minors, extra punishment for use in a crime, things like that. Those are very straightforward, and maybe
right.
There's some other controls you could argue for, but not outright prohibitions.
Right, and that's the big problem, because even if you, a lot of this logic along the way, you could question each part of it. But even if you agree that, for instance, mass shootings are a modern problem that didn't exist at the founding, and they're facilitated by, they're something created or facilitated by modern firearms technology. I mean, all that is obviously questionable in and of itself. But even if you agree with that, you'd still have to find analogies that are a good match for both the how and why. And from what you're saying here, those just don't exist.